SJC-12128, Commonwealth v. Atreo, Crowley-Chester.
Good morning, Mr. Michaud.
Good afternoon, Your Honors. Attorney Patrick Michaud for Atreo, Chester, Crowley. Three issues I believe I'd like to address here are, one is whether or not there was error by the appeals court to apply de novo review to the CAD report that was explicitly excluded by the trial judge during the motion to suppress. The second one is if there was not error in that decision, then the defendant believes that there was error in the application of the analysis of that CAD report. And third is the analysis of the word choice by the trial judge, where he used the word necessity, and they're distinguishing or categorizing that was an improper determination and should have used the words reasonableness. With respect to the de novo review issue, I would suggest that the trial judge had specifically excluded that CAD report in his analysis. Although he referenced it in his decision, he specifically excluded it.
How can you have it both ways?
Well, I understand that argument, but I would suggest that what he did was he relied upon the testimony and the credibility and the determination of what he believed was at issue in his determination.
It was an exhibit, right?
It was an exhibit. He initially had indicated that it was hearsay.
Offered by your client.
Correct. And the trial judge had indicated that it was hearsay, but he was going to let the defendant offer it in as an exhibit.
I mean, just as a technical matter, if it's an exhibit, why is it wrong for the appeals court to look at it?
I would suggest that it's wrong in that the trial judge specifically said he was not going to rely upon that exhibit.
But if there was a videotape confession, different case, and the trial judge said, I listened to the testimony of all the police officers and whoever was there, and I find that it was voluntary. I'm not really relying on the videotape. Wouldn't an appellate court have every ability to look at the record that was before the court, whether or not the judge accepted it and make an independent assessment?
Oh, that's a good point. I would suggest that certainly that's an argument that I would agree with that argument. I would say that in this case, it's a CAD report that offers some statistical data.
Or the same with the photographs that you rely on. Even if the judge didn't reference the photographs, and we look at the photographs and say, geez, it is a residential area, you're right.
Yeah, I think there's some subtle differences in the two, but I do agree with those points. Even if they were not in error to de novo review of the CAD report, I would still suggest that the CAD report was consistent with what the retired FBI agent, Bennett, I believe his name was, had testified to, in which he stated there was a sprinkling of more serious crimes in that vicinity, that kind of three-street area vicinity. I believe the amount of incidents were somewhere in the range of 120 to 140 incidents, and most of them were either false alarms from a building of sort or just telephone calls. There were a handful of more serious complaints or calls for the police to go out. But with respect to William Street, which the judge specifically honed in on, I believe there was just one. So I would suggest that even if we take the CAD report and we look at it, you're still looking at exactly what the FBI agent suggested, which was a sprinkling. So I would suggest that the trial court judge's decision was not inaccurate or not incorrect. Now, with respect to the word choice of necessity, looking at the entire decision, in the transcript, throughout, the judge, certainly understands the application of the reasonableness standards. I don't believe that the trial judge should be held to the fact that he used the word necessity should have his decision overruled.
I mean, I hate to say it, but I happen to be the author of Oliveira, and Oliveira says if the vehicle was seized for a legitimate purpose, we look next to whether the seizure was reasonably necessary based on the totality of the evidence. Isn't that now the standard? Reasonably necessary?
Certainly, certainly. I think, again, the appeals court is holding the judge to a heightened level of scrutiny with respect to the word choice. I think it's pretty clear, I believe it's pretty clear that the trial judge knows the standard and was applying the standard. The fact that he perhaps phrased it in a different way doesn't mean that he was incorrect in his decision. I believe there's also the Dunn case, which states that the police acted reasonably deeming necessary to impound. So the word choices can differ on occasion, certainly in some of these decisions. So that's why I believe that the trial judge's decision to allow the motion to suppress should be affirmed. If we look at the particular facts of the case, these individuals were already parked. They were parked in a legal spot that allowed overnight parking. There was the officer's testimony was that there was no concern of public safety. The only concern they had was to whether or not the car would be broken into, I believe.
But an objective standard, the appeals court looked at public safety.
Yes, they did. But I would suggest that there was no public safety issue based upon the facts of the case and the testimony that came out.
Let's take the 6 reasons they said that there were. Trying to hide a dark item behind the center console, dropping crack cocaine from the pocket, defendant slouching down when the cruiser spotlight was directed at the Honda, plain sighting of a knife in the center console, lights off and furtive movements, and last and certainly, in my view at least, high crime area. So they list 6 reasons.
Yes, and one of them, certainly, the knife was discovered to be a Swiss Army knife.
We don't do it after constitutional justification. We decide whether or not there's constitutional justification at the time of the
Oh, no, for the initial investigation and arrest, certainly, that's not the issue. It's whether or not it should have been impounded.
Sure, fair enough. That's a fair point.
So the public safety issue, I would say, is there's a knife that really isn't a knife that's going to hurt anyone. The real issue, I suppose if they had enough crack cocaine for distribution, then they would change the situation or this case. And I would agree that would entitle them to impound it. But I would suggest...
That be?
Well, I would suggest that certainly that if they were involved in distribution of drugs, that certainly changes the parameters of what individual use.
They will have taken all the drugs out, so I'm just not, I'm confused.
Well, I would suggest that the individual use doesn't suggest that they're involved in any criminal activity other than personal use. That's my only point with respect to the individual use versus...
Because the police could assume that there'd be more likelihood of breaking
Well,
into it if it had more drugs in it?
Well, I think they certainly would be in a position to look a little bit further or deeper into the vehicle, determine anything else.
Oh, I see what you mean. I see.
Also, I would suggest that the Commonwealth conceded that the trial judge had implicitly deemed the decision was not reasonable. And again, that goes to the word choice and whether or not he was correct or accurate. And if there's no other questions, I would rely on the brief.
All right, thank you.
Thank you.
Ms. Payne?
May it please the court, good afternoon. My name is Assistant District Attorney Cynthia Payne, and I represent the Commonwealth. Here, the Commonwealth is asking this court to reverse the motion judge's allowance of the defendant's motion to suppress the fruits of the inventory search. Here, the appeals court was allowed a de novo review, and that's based on the motion judge's reliance on the CAD sheet, CAD being the computer-aided dispatch.
And what does that add?
I'm sorry?
What does the CAD evidence add to your analysis?
The instances of crime that took place,
This all goes to the high crime area,
that's correct.
and no other factor.
That's correct.
Okay. Now, do you agree that Oliveira requires the Commonwealth to show that it would have been unreasonable to have allowed the vehicle to remain where the driver chose to park it?
Well, in Oliveira, admittedly, the court had indicated that where the defendants already parked the car.
As here.
As here. Although I would note that the defendant was in the car, the engine was running. I would note it's not perhaps as straightforward as Oliveira. However, the Commonwealth would suggest that it was, in fact, it would have been unreasonable under the circumstances to leave the car in that
We do
spot.
have a residential area, right? I know there was a vacant lot, but that's across the street. The photograph that I saw, it's a row of houses and there's spots and people parked there.
Actually, I believe the vacant lot was right next to.
Okay, but either
But
way,
yes.
we're talking about a residential street.
That's correct. But I would note, and yes, as the appeals court noted, that in this particular area, during the 6 months that the CAD showed, there were 7 B&Es, breaking and enterings, 1 armed robbery, 4 larcenies. There was 1 break to a motor vehicle. There was 1 B&E to a motor vehicle. And I don't know if the break to a motor vehicle was just shorthand for breaking and entering. There was a vandalism. There were a number of alarms that weren't false alarms. And there were also a number of assists, and it's unclear what sort of call those are for. It could have been just to help for something, but it also could have been for something more serious, a theft or a robbery.
With regard to the high crime area, is there any relevance to anything other than break-ins and vandalism of cars? I mean, let's assume there are a lot of murders, but how does that bear on the danger to the car?
No, you're correct, Your Honor. Just in
So
fact,
how many, we had 2 break-ins and 1 vandalism of a car over the course of 6 months?
well, I would suggest that B&Es to a residence, that breaking and entering is a breaking and entering. I would suggest that the armed robbery is still involving theft.
Okay, so, and this is over 6 months. I guess the question is it your position then that the police can impound any vehicle found in a high crime area?
Well, when it's related to thefts or vandalism, I would
Well, I
note.
mean, so, that's my question. So basically, if a car is parked, even if the person has parked it, and I take your point that this person hadn't left the car, was still in it, but he still put it there, it wasn't the police who put it there. And if that car is in an area which is determined to be a high crime area which has some number less than 10 break-ins or vandalisms of homes or cars within a period of 6 months, that is sufficient for the car to be impounded?
I would say that we have to look at the type of crime, but I would also say that the 3 streets that are on the CAD sheet are the street in question and the 2 streets next to it. It doesn't include any other streets. As the motion judge noted, he had personal knowledge, and he indicated that he wasn't going to consider the personal knowledge in his decision, but that this particular area in which William Street was a part was a high crime area. And again, I would note that there were a number of alarms on this case, but I think more importantly is that the police, this is looking at the case in hindsight. The police officer at the time testified that he was aware of a number of thefts and vandalism that had taken place in the area, that he himself had made a number of arrests for stolen motor vehicles. He himself had made a number of reports, he or his partner, for that particular crime. So I would suggest that it was reasonable, and it would have been unreasonable for the police officers at that particular time to leave the car where the defendant was, where the driver was under arrest, where the defendant didn't have a license, where the officers were aware of this particular area. The time of night, it was 3 o'clock in the morning.
But you, I mean, there are consequences here, which is pragmatically, if you live in a low-income area, which is more likely to be an area in which minorities reside, that means that if you park your car in that area and you get arrested, that is sufficient to impound the car. But if you live in a middle-class or wealthier area, it's not. That would be isn't that the consequence of your reasoning?
Well, one, we don't know who owned the car. We know that the defendant did not own the car. We don't know if, in fact...
Okay, but why does that matter? It seems as if the only thing that matters here is whether it's a high-crime area. That was the sole criteria for justifying the impoundment.
I would suggest also the fact that the defendant didn't have a license, that the owner was under arrest, that it was 3 o'clock in the morning.
Well, I understand, but then he still had the choice of locking the car and leaving it there or not. That's the issue. I understand they were arrested, but police officer is faced with, do I impound the car and search it pursuant to the inventory policy, or do I just lock it and leave it there? And it seems to me that the position you're taking would be that if it is in a low-income, likely minority area, which is where high-crime areas of the type you describe are more likely to be, that those cars will get impounded and other cars will not.
Well, looking at what the case law indicates, I would suggest that high-crime area is one of the criteria, and we had testimony that this was a high-crime area. We have a dispatch sheet that indicates that there was, in fact, a number of those type of incidences that took place, and I would suggest to you, I would suggest to the court that it would have been unreasonable for the police officers to leave the car there.
Are you saying, though, in response to Chief Justice Gantz's question, that if the only reason to impound the vehicle is because it's going to be left in a high-crime area, that's enough in and of itself?
Well, I would suggest that there were really two rationales here.
I understand that, but let's go to Chief Justice Gantz's question. If the only rationale is that it's a high-crime area, is that enough to impound a car?
I would say no, if that's the only reason. But here, we have more than, and maybe I'm not understanding your question, Justice Gantz, but here we have more than a high-crime area, I would suggest. Here we have the time of night. Here we have the fact that both individuals are arrested, and the fact that, again, according to the case law, the Commonwealth suggests that it would have been unreasonable at the time based on what the officer knew, the fact that he had knowledge that this particular area had a number of thefts or.
And unreasonable?
Well, I know that's what the Oliveira, that where a car is parked, and arguably this car was parked when the officers came up to it, whether or not it would be unreasonable to leave the car. I would suggest that this case is analogous to the Commonwealth v. Eddington. And I know in Eddington, the police pulled the car over. However, in Eddington, it was a lawful spot, just like this particular case. Neither individual was able to drive the car. In that particular case, the motion judge actually found that just the fact there was high crime, because there had been no testimony of thefts or vandalism, that wasn't enough. But this court reversed that and said police must act reasonably, and it's a case-by-case analysis. And I would suggest that in this particular instance, the police officers were not unreasonable in what they did. And the Commonwealth would ask that you reverse the motion judge's decision. unless they're for the,
Do we employ the clearly erroneous standard here? Or are you saying this is now de novo, even though it wasn't, because all that you look at is the CAD?
well,
Judge looked at more than CAD. The judge had a whole evidentiary hearing.
yes,
So I don't know of any situation in which we have said where there's an evidentiary hearing, we ignore it and look only at one exhibit, and then we do a de novo analysis.
I would suggest in this particular case, even if the Officer Longo's testimony is excluded on credibility reasons, although the judge had found everything that he had done up to that point was fine, that there was, the CAD itself is enough. Also, the motion judge's personal, well, I'll strike that. I would suggest a de novo review.
Okay, thank you.
Thank you.